Peace, love, and prosperity to all of humanity on planet Earth. This is Abdul Al Kabir, Sultan of the Empire of Morocco, the de jure and legitimate Sultan as of June 8, 2024, as distinguished from the fraudulent Kendon, who has conducted a failed coup attempt against the empire to fraudulently take a seat as the Sultan. That will be settled in due time. Fully settled. It's already been settled, but it'll be further settled in due time. Hope all is well with all of you on the call. Today is Sunday, January 25th. And we are continuing on with our continuing with our uh Franco-American correspondence, the French Protectorate of Morocco relinquishment of extraterritorial jurisdiction by certain foreign powers. And this is the attitude of the United States. And so, as a recap, uh, upon signing the Treaty of Fez in 1912 between France and the Empire of Morocco, which the Sultan at the time was coerced to sign this treaty. This was a colonial treaty, um, in which the empire fell into colonial status, with France achieving sway over the empire. With that newfound power, they thought proper to correspond with all the powers they refer to as the powers, the European powers, the signatory powers, regarding an adhesion or their acquiescence or um, recognition of the new agreement, being the Treaty of Fez in the French protectorate that was established under said treaty. Um, One of the concerns that the United States had, because France was calling for the United States to relinquish their consular jurisdiction uh, within the French zone of Morocco. French zone meaning the areas in which France had authority, because you also had the Spanish zone. Spain also had a protectorate. So the United States, within its borders, had French uh, authority, had to deal with French authority as well as Spanish authority, which is interesting. Interesting. That's why you have in Louisiana the French quarters. It's a lot of French influence in Louisiana, and then in other parts you have Spanish influence. Have you guys noticed that? Yeah, that's a real question for the floor.
Indeed.
Yep. Okay.
Yeah, that's why it says that's why the purchase Louisiana purchase mean a lot too.
Which wasn't a
Because
purchase, but that's another story, right?
all right,
And so, as you see, they say following the traditional American foreign policy, which forbids participation by the United States in the settlement of political questions, which are entirely European in their scope. Where does that language come from? Can anyone tell me that that the participation by the United States in settlement of political questions, which are entirely European in their scope, that the United States are forbid from that, from having any political interest in Morocco? This is the French, uh, the American Secretary of State corresponding back to the French ambassador from the first correspondence on January 8, 1913 by the French ambassador. So my question is, where did the Secretary of State derive that language where it states that uh, American foreign policy forbids participation by the United States in the settlement of political questions, which are entirely European in their scope? The government must refrain from any expression of opinion for or against such part or parts of the Franco-Moroccan Protectorate Treaty because they have no political interest in Morocco. Where do they get that language from?
They
You guys
got that
recall?
from Moroccan government.
Wrong answer. Try again.
Britain.
No. Thanks for the attempt. They got it from President Roosevelt. Um, do I have it up already? Doesn't look like I do. Yes, I do. Let's show you where it came from. And I've given you this jewel before, so I'll give it to you again. Pay attention. This is what treaty are we looking at? What treaty is this, Morris? Look at the signatories. Germany, Austria-Hungary, Belgium, Spain, United States, France, Great Britain, Italy, Morocco, Netherlands.
Madrid?
No.
The Act of Algeciras.
Yes. All right. So what we're looking at over is this the additional protocol. So that's the hint. If you know that it's the treaty, then where did they get the language from? What am I looking up? Okay. President Roosevelt wrote a proclamation. More, take notes. Take notes. Pull out your pen. Take notes. President Roosevelt in 1906 wrote a proclamation regarding the act, the ratification of the Act of Algeciras. Brother Rashid,
Sir,
read, start right here.
the government of the United States, having no political interest in Morocco and no desire or purpose, having animated it to take part in this conference other than to secure for all peoples the widest equality of trade and privilege with Morocco, and to facilitate the institutional reforms in that country, tending to ensure complete cordiality of intercourse without and stability of administration within for the common good, declares that in acquiescing in the regulations and declarations of the conference and becoming a signatory to the General Act of Algeciras and to the additional protocol, subject to ratification according to constitutional procedure, and in accepting the application of those regulations and declarations to American citizens and interests in Morocco, it does so without assuming obligation or responsibility for the enforcement thereof.
That's the act about that's President Roosevelt. What's that? Further up, right? So that was just a portion of it. So you see where it says having no political interest in Morocco. So they have no political interest in Morocco. This is the short version of it. That's not the whole declaration or proclamation. There's two versions of the Act of Algeciras. One that's in um French and English, and the other one is in just strictly in English. That's the one that we're looking at. That's strictly in English. So it doesn't have the full uh, proclamation. But I just wanted to show you where it came from, just briefly. So it was President Roosevelt who said that the United States has no political interest in Morocco, and that's where they get this from, following the traditional American foreign policy. So it was established as a foreign policy an American foreign policy that uh, which forbids participation by the United States in the settlement of political questions, which are entirely European in their scope. That language was also stated, but you didn't see it in that read because, like I said, that's the shorter version. We already went over the long version when we went over the Act of Alcaceres. So that's why I'm surprised you guys didn't know where where it came from. So at any rate, um, what else did we learn? We learned that the Moors are in Morocco. We learned that the United States wanted to maintain certain rights and privileges afforded to them by the Treaty of Peace and Friendship to secure their recognition and adhesion to the new agreement, which was the Treaty of Fez, giving France the sovereign authority. Right? They also wanted certain um, cases to be settled, like in the case of the gentleman who uh, his property was infringed upon because they built a highway on the property. And so the litigation was being held up by which court, Morris? Do you remember what court was holding up or presiding over the litigation?
Consular
Moorish,
Court.
Moorish courts. So in 1914, there literally was Moorish courts. When have you known that? In 1914, they're telling you about Black Wall Street. You know nothing about Moorish courts. Shameful. We were miseducated. And who helped miseducate us? Our own people. So anyhow, we'll start on the correspondence of July 16th, 1914, which was the French Charge d'Affaires to the Secretary of State. Would you go ahead and begin this read here, good bro?
Um, the French Charge d'Affaires to the Secretary of State, French Embassy, Washington, July 16, 1914. Mr. Secretary of State, in the course of the negotiations for the suppression of consular courts and the extinction of extraterritorial rights in the French zone of the Sarifian Empire, it was occasionally objected to the representative of the Republic that it was not possible for the powers to take any further responsibility in the fate of their Moorish proteges.
Who are the Moorish? What do they mean by Moorish proteges? Who are they?
Protect their party the most.
The black Negroes and African American.
Anyone else? Anyone else want to give it another shot?
Oh, and those are the subject. The proteges are the ones the like President Obama, things of that nature that worked in government. Those are the that's what that was.
Doctors, lawyers,
Mm-hmm. Yeah.
police,
The elite Negroes, the high class
the
Negroes,
boule,
Boule, Boule Negroes, high society Negroes, gatekeeper Negroes. Those are the proteges. And then, so therefore, the Moorish subjects is everyone else. However, a Moorish protege is still a Moorish subject. It's just that the term protege is just a higher designation to an average black man, if you will. So proteges, they got privileges and immunities and all types of additional protections. The Moorish subjects only have judicial protections. They don't have privileges and immunities and any extra anything. That's the difference between the two. So what did they say? It said it was occasionally objected to the representative of the republic when it says the republic is referring to the French Republic. So they refer to themselves as the republic, and they refer to the United States as the federal. Sometimes they'll say the federal government and stuff like that. You'll see of the republic that it was not possible for the powers. Who are the powers?
All signatory parties, the Europeans.
Mm-hmm. To take any further responsibility in the fate of their Moorish protege. So it's not just the United States. It's not just Barack Obama. It's not just Colin Powell. It's not just uh, Maxine Waters, and the list goes on. Because it's anyone that held similar positions in France. Any other black man who held similar positions in Great Britain, Spain, Italy, so on and so forth. The powers. That's why I said the powers. So all of them, right? They're talking all the powers. It was not possible for the powers to take any further responsibility in the fate of their Moorish proteges. You see how we're just getting handled by Plymouth Rock that landed on us? Continue, brother.
There will seem to be some foundational. There will seem to be some foundation for that feeling. In fact, under the provisions of Article 12 of the Franco-German Agreement of November 4th, 1911, whose full scope is given in the explanatory letter, the government of the Republic would certainly have the right, after the discontinuance of the consular course, to ask what protection be done away with. The strict legal effect of this would be to place under native jurisdiction the proteges who, under the present system, are enjoying consular jurisdiction.
Mm-hmm. So what did they say? To ask the protection to be done away with. The strict legal effect of this would be to place under native jurisdiction the proteges who, under the present system, are enjoying consular jurisdiction. See, as you continue to read, you'll see something very interesting. It'll become clear to you, first of all, that there's a transition taking place, and all the powers need to adhere to this transition. And that transition is the establishment of the French courts in Morocco because of the newly found authority by France in Morocco. So now here comes France flexing their authority and all the power. In this case, we're talking about the United States. This all includes the protections and the governance, i.e., the governance of the naturalized subjects of Morocco, who, at least in American jurisdiction, became Negroes, blacks, and coloreds. There had been a thorough and speedy Americanization of the former Moors. Where did we hear that before, Moors? This one you got to be able to answer, because this was the Moors' favorite document once upon a time. Where did we
Was
hear
that
that?
1875, that Philadelphia document?
Yep.
House Law Resolution 75.
Mm-hmm. Resolution 75 of Philadelphia 19. What year was it?
1933.
Mm-hmm. Did it say in that document that the Moors came from the plains of Morocco?
Yes, sir.
It did, didn't it? Okay.
Sir.
1952, right? I mean, 1933, right?
Yes, sir.
Okay. Well, then what was the kingdom established?
1956.
Oh, so then who in the world could they have been talking about in 1933 when it said the plains of Morocco?
Talking about the Empire of Morocco.
23 years
Clearly,
later.
the Empire of Morocco. All right, brother, continue reading. Let's see what else they say.
Uh-huh. But with a view to obviating the hardships that might thereby be brought upon the Moorish subjects, thus deprived of protection, the government of the Republic is ready to declare them to be, as long as they live, under the jurisdiction of the French courts set up in the protectorate.
Did y'all hear that? But with a view to obviating the hardship. Now you see even clearly the difference between a Moorish subject and a Moorish protege. The Moorish subjects, the regular Moorish subjects, deal with hardships. The Moorish, the average Moorish subject deals with hardships. The Moorish proteges do not. Why? Because they have privileges, additional privileges. They get houses, great salaries as gatekeepers, but with a view to obviating the hardships that might thereby be brought upon the Moorish subjects. Thus, deprived of protection, the government of the Republic is ready to declare them to be as long as they live. Forever? Forever, ever? Forever, ever? Really? This how we gonna do it? As long as they live under the jurisdiction of the French courts set up in the protectorate. Mm, mm, mm. So we just saw the difference between a protege and a Moorish subject, didn't we? Both of them are the same
Oh,
people, but a different class, a different status. See, that's the jigaboo high class Negro.
proteges carry out the will of the colonists still. That's why they are
That's right.
privileged.
That's right. Like you said, your Boulets, your Madam Adam C.J. Walker and your W.E.B. Du Bois and all of them, the talented 10th and all this high society Negro stuff. While everyone else are dealing with the hardships.
They know the truth, but they refuse to tell it because they're getting paid.
Because they want to maintain their privileged position. But that is equivalent to stepping over pennies for stepping over a dollar for pennies. Because you can accept the privilege or you can reclaim the whole thing. You chose the former. You chose to enjoy the privileges and allow them to govern the whole thing. Isn't that stupid? That's why I keep telling us. That's why I keep telling us, get off that white man bandwagon thing. Better start that sword that you got aiming at the white man, you better redirect it. Because there ain't nothing worse than a nappy head devil. It's him. It's the nappy head, whether fezzed up or not. It be your own brothers and fezzes and turbans or just regular raw naps that will put you into slavery. It's your own people, a bunch of chumps who would rather a mansion, a mega church, and a couple of Benzes over the sovereign authority founded and established by their ancestors. So if you want to say blue-eyed devil, well, let's talk about the nappy-head devil, because ain't nothing worse than that. He's a traitor. See, treason runs deep in our bloodline, doesn't it? Didn't we experience treason just a minute ago?
Yeah.
October 1st. We just spoke on the treasonous activity briefly on the onset of the call. I always have to do that to make it clear for the record, for the world to know who the fraudulent sultan was based in treason and who's the de jure sultan who withstood an onslaught of treasonous activity employed by one disgraced and removed Chief Judge Jermaine Diaz Spencer. Treason is just what the Negroes do. And treason is what the Negro Jermaine Diaz Spencer attempted. Well, no, he did do treason. He attempted a coup. He just tried the wrong one, didn't he?
It's long.
That's our people. You are who your ancestors were, without a doubt or contradiction. So if your ancestors were the sellout Moors, then that's what you are today. It just runs down. It just goes. It's a cycle down your bloodline. If you were one of the righteous Moors of the time, then you are one of the righteous Moors today. So we're still fighting the same enemy today, which is self. However, it doesn't change the fact that you're still a Moor, because your nationality is your national, your bloodline is your bloodline. What you have to do now is identify the bad actors and deal with them accordingly, i.e., AMPAC 2.0, that we just identified the latest bad actors who, upon decolonization, will be dealt with accordingly. They have already been dealt with accordingly. They'll be dealt with firmly. Let's say that. Islam. So we see the difference between the Moorish subjects and the Moorish proteges, and which then allows us to see what it is that we were dealing with based on a split up nation of people. Some were dealing with the hardships as just basic subjects. Some were enjoying additional privileges as proteges. And those who were enjoying those additional privileges kept their mouth shut to maintain those privileges and forsake their own brothers and sisters who knew not about any such agreement. And this is why they all will get dealt with in due time. Starting from as of October 1st, 2024, AMPAC 2.0, and all the way back to W.E.B. Du Bois and them. Everybody's going to be exposed. Islam? Okay, brother, continue.
Long.
Do you recall where you were?
Yes. This would place them in this respect on an equal footing with the person subject to the jurisdiction of the former protecting power, and not with the natives. My government authorizes me to make its intentions as to this known as pardon me, to make its intentions as to this known to the federal government, being convinced that they are likely to remove any apprehension concerning its proteges, if, after availing itself of the rights conferred upon it by the existing provisions, the government of the Republic should procure the abolition. I avail myself of this opportunity to enclose 3 copies of Louis Renault's preface to the codes and laws in force in the French protectorate in Morocco, which brings forth the value and importance of the legislative work of the protectorate, showing as it does the guarantees extended to all foreigners in Morocco. That paper ought to expedite adhesion to the new system on the part of the few powers that have not yet relinquished the exercise of consular jurisdiction.
So there's a few powers who haven't yet exercised the relinquishment of consular jurisdiction. So they're going around forcing the powers, the European powers, to relinquish the exercise of their consular jurisdiction, which is based in the regimes of capitulations, by the way. You'll learn, we'll get into that. So that's the conclusion of the um, French Charge d'Affaires to the Secretary of State. The first letter, that one was on July 16, 1914, and here's another one. They came back again with another correspondence on the same date, on the same date. Continue, bro.
What? The French Charge d'Affaires to the Secretary of State. Is this the same thing?
No, that's what I was just explaining, that they sent two letters on the same day.
Pardon me, pardon me. French Embassy, Washington, July 16, 1914. Mr. Secretary of State, by a letter dated February 13th, last, Mr. Bassett Moore made known to the embassy the federal government's intention respecting the acceptance of the jurisdiction of the new courts instituted by us in Morocco for persons subject to American jurisdiction.
Did you hear that? You see, that's what I'm saying to you. There's a transition taking place, right? So he says, by letter dated February 13th, last, Mr. Bassett Moore made known to the embassy, the federal government, you see, they refer to him as the federal government, the federal government's intentions respecting the acceptance of the jurisdiction of the new courts instituted by us, the French government, right, in Morocco. So the French government instituted a new court in Morocco. Well, what were the reforms? Administrative, judicial, educational. See, so that's part of the reform. But this is the part. For persons subject to American jurisdiction, who they talking about?
More so.
There you go. Because remember, they said that they were going to protect the black man forever. As long as the black man live, we're going to protect them with our courts. Y'all remember they just said that in the previous correspondence. So now here he comes again, saying the same thing in different words. But now he's saying persons subject to American jurisdiction. They're talking about the Moors. Continue, bro.
Well, at the same time, Mr. Bassett Moore expressed a strong desire to arrive at settlement of various questions affecting American interests in the Sharifian Empire. The resident Commissioner General of the French Republic, to whom the State Department's note was forwarded by the Minister of Foreign Affairs, has returned to Mr. Viviani in answer, the substance of which I have the honor to communicate to you. With the exception of two clearly defined cases, Vacuum Oil Company and a Benatil case, which will be fully explained herein after. The federal government formulates but does not specify reservations or demands of a purely general character against the protectorate government. There is no question about the federal government being, as much as any other, warranted in watching over the economic rights and interests of Morocco, which, as put by Mr. Bassett Moore, are safeguarded by the treaties concluded between the foreign powers and the Sharifian Empire. But it is equally true that the protectorate government is bent on respecting to the fullest extent in favor of Americans as well as all other foreign citizens or subjects the principle of economic equality.
Okay, pause right there. The principle of what?
Economic equality.
Remember, I was telling you all that the triple principles serves both sides of the contract. So it's not just the sovereignty and independence, integrity of domains, and economic liberty of the Moors and the Sultan and the empire, but also those of the signatory powers. This was because of the most favored nation clause. They wanted the Sultan sought to put them all on equal footing. So everyone had economic liberty without any inequality. Without any inequality, that's the key word. So everything was equal, it was equitable. They brought the Sultan, by way of the act of Algeciras, brought equity, gave them equity, I should say. You see? Um, but what else is it saying? There is no question about the federal government being as much as any other warranted in watching over the economic rights and interests of Morocco, which, as put by Mr. Bassett Moore, are safeguarded by the treaties concluded. They're safeguarded by the treaties concluded between the foreign powers. This is how they refer to themselves, because that's what it is. It was common knowledge. It just is. I mean, that's what they all understood it to be, because that's what it was, and that's what it still is. They're foreign powers, foreign to Morocco, and while at the same time those states are owned by Morocco, the foreign powers and the Sharifian Empire, all of them under treaty agreement with us. We are the Sharifian Empire. They are the foreign powers. But again, the Sultanate, the office of the Sultan, was being held by who? Arabs, not Moors per se. Even though it still bugs me out that Abdul Aziz looked like Little Wayne. But the Arabs, so you have to, okay, so let's specify it. Because you just can't say Arabs. You'd have to say pale Arabs versus the Arabs. Because the Moors are the Arabs. Oh, oh. We're the original everything. We are the original Arabs, and then here comes the pale Ashkenazis. See, the Ashkenazis are master manipulators and master chameleons, if you will. They will assimilate someone. They're master assimilators. Let's put it that way. They assimilate. Master leeches really is what the real term is. Masterful leeches. They assimilate and take over your whole character, your whole culture. They're the Arabs. They're the Jews. No, you're not. You're neither. So um uh that's the conundrum. All right. But it is equal true that the protectorate government is bent on respecting to the fullest extent in favor of Americans as well as all other foreign citizens or subjects, the principle of economic equality. So, what is it that you think that the United States is going to demand of us? In reading this, what do you think they're going to demand of us? Take a wild guess.
The same thing.
The same exact thing. What about our economic liberty and equality? Can we maintain that? Well, if they've been listening to me, we are seeking to adhere to all the provisions of the treaties. Period. So if the treaty says that you have economic equality, then you got economic equality. Simple as that. But it also says that you got to pay taxes. Simple as that as well. So whatever the treaty says, what we're going to do. That's all. That's it. They also talk about Article 11 of the Treaty of Madrid and Article 63 of the Act of Algeciras, which talks about their right to hold property. We'll be reading some of that right in a few from right here in this correspondence is being brought up. See, they're trying to maintain that. This gives you a hint as to which direction we need to go. Because think of the French government as the Moorish Empire reconvened. Because the same way we're seeing that there's a transition taking place between the French and the empire and the powers, whereas they have instituted a new court in a French court in Morocco. The same transition we will see take place yet again, but this time now it's the empire itself as the reemerge as the reemergence, and it's not me who's doing the corresponding. It's our ambassador, minister of foreign affairs, charge d'affaires. Do you see? So these are the same things that they're going to be requesting or demanding of us, that we adhere to specific treaty provisions that give them and lock them in with these so-called rights within Morocco. All right, brother, continue. The principle being once more evoked.
The principle being once more evoked. Hold up, I got you. The principle being once more evoked, the reservations or claims put forth by the federal government are so general in their character that, from the fact that the importance of American interests and the number of persons lying under American jurisdiction appear to be out of proportion to the set of reservations and objections offered. The question arises whether Mr. Bassett Moore's letter of February 13, 1914 is not aiming, after all, and while the federal government expresses itself in favor of the reforms, to reopen the question of the very principle of the protectorate regulation powers. As a matter of fact, it does not seem possible to maintain the protests that have been made against the protectorate government. Upon careful examination of every one of the questions presented, one, as regards the contemplated martial law in cases of contraband of arms, the matter having been settled by dropping the subject need not be brought up anew. Two, the federal government's statement about protection leads one to believe that the meaning and scope of the protectorate's intentions have been misunderstood. Indeed, it never was heretofore our intention to do away with the protection, but we meant merely to stop its improper use through a revision of the list, jointly with the delegate of every legation concerned provision. Furthermore, for such a revision was made in the Franco-German treaty to which the government of the United States gave its adhesion. It is important, however, to take notice of Mr. Bassett Moore's assertion that the choice of the American protégés rests ultimately with the government of the United States. For the right to choose can only be exercised within the limits wherein it conforms to the treaties of the provisions of which the Moxon may remind the powers concerned, in order to obtain a return to the enforcement of those conventions.
Did you hear what you just read? Read that paragraph again, please.
It is important, however, to take notice of Mr. Bassett Moore's assertion that the choice of the American protégés rests ultimately with the government of the United States.
Pause right there. Who are the American protégés?
The
Moore's
Obamas,
The Bolay.
yeah, the privilege.
Mm-hmm. But it also includes who? This statement, this paragraph, I should say, also includes who? It's not limited to the protégés. Who else does it include?
Moore's subjects.
What?
Moors.
What? No. You're right. What? This is another question. What? Let's see. What interpretation could you draw from this? Use your mental faculty.
All of his municipalities.
No. Okay. For the right to choose. Where have you heard that language?
Okay. In the Treaty of Madrid, 1880, Article 15.
Now read it again with that same understanding. It is important, however, to take notice of Mr. Bassett Moore's assertion that the choice of the American protege rests ultimately with the government of the United States, for the right to choose can only be exercised. So you're saying that the United States you have to get permission from the United States to choose the entire submission?
They quit Morocco.
Is it, but isn't that what
Copy
they
in the
brought
other.
that same argument to the ICJ in 1952, and ICJ struck it down and said, no, the Moors don't require prior assent. They can just do it. Like Nike, baby, they can just do it. So they say the choice of the American protege rests ultimately with the government of the United States, for the right to choose can only be exercised within the limits wherein it conforms to the treaties, Treaty of Madrid, Article 15, of the provisions of which the Moxen may remind the power. So it says that the Moxen can and may and should and shall remind the powers. So right now, the Moxen, the Moorish government that's administering the empire, has the power and authority to remind the powers concerned of who is the sovereign around here. Y'all get what I'm saying? We are, because see, this is the difference between the Moroccan nationality being obsolete and without effect versus absolute with full effect. Because it even goes on to say, in order to obtain a return to the of enforcement, I'm sorry, in order to obtain a return to the enforcement of those conventions. That means that what? The Moroccan nationality has to now become absolute and with full effect in order to obtain a return to the enforcement of those conventions. What are the conventions? What are the conventions? I'm listening.
All the Vibe Moorish
Madrid,
treaties.
Algeciras,
VCCR, VCDR.
No,
Convention
no,
of
no, 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 no,
Information.
not VCDR. They said they were specific. You said it, brother Wazir Belinke. The conventions are the
Madrid.
treaty agreements with the European powers and the Moorish Empire. Like you said, brother, the Madrid Convention, that's why it's called the convention. Algeciras is a convention. Whenever you have a multilateral treaty, meaning several states, that becomes a convention versus a bilateral treaty between the United States and Morocco, as an example. The Act of Algeciras having 12 signatory powers, that's a convention. So did y'all see? So you have to return, and choose the entire submission to the laws of the empire in order to obtain a return to the enforcement of those conventions, meaning of the Negro, blacks, and coloreds, right, subject to American jurisdiction. You don't have the authority, the full effect to enforce any of these treaties. But they're saying that it requires you that we require their permission, and that's a hail to the no. No, sir, Bob. No, it does not. We can just do it because it's a mandate. And who set forth that mandate? That's a question for the floor.
Empire of Morocco.
Who set forth the mandate? Who set forth the mandate? The Sultan. The Sultan set forth that mandate. Who was the Sultan for the Madrid Convention. We gotta know our sultans. Hassan the First. Who was the sultan for the Act of Algeciras? Oh, come on. You gotta know the Act of Algeciras now. You look like Lil Wayne. I just said it.
Abdulaziz.
Abdelaziz.
Abdulaziz. Pardon.
Okay. Continue, brother.
Well, it is in,
Right here. If the powers would forego.
if the powers would forego, in principle, their consular jurisdiction, we might, per contra, take up such an enforcement in as liberal a spirit as possible, and to that end, come back to a bilateral revision as provided in the Franco-German Treaty. 3. The remarks offered in regard to the original circular, November 1, 1912, laying down rules for the purchase of land, appear to have been prompted by an incomplete study of the subject on the part of the Washington government. On the one hand, the consent of the government referred to in Article 11 of the Madrid Convention and Article 60 of the Act of Algeciras, and again mentioned in the regulations of November 1, 1912, does not, of course, apply to any but those parts where such consent is requisite. That is to say, without the 10 kilometer zone around the ports and the 2 kilometer zone allotted to Azamor.
Those were the areas in which they didn't have that same privilege or right. Excuse me, but notice that in this correspondence, they're invoking what? The Treaty of Madrid, Article 11. That's France. Us, here real soon, will be doing the same thing, but instead of talking about Article 11, what article will we be talking about, invoking?
Article 15, Section 1.
All right. Thank you. And then in the Treaty of Madrid, all the articles basically. We're going by chapter. Chapter 1 is the police. We're not even going by articles, we're going by chapters. Chapter 1 is the police. Chapter 2 is the contraband of arms, control of weapons of mass destruction and things. Chapter 3 is the banking. Chapter 4 is the taxes. Chapter 5 is the ports. And chapter 6 is the public services and public works. So we'll have to invoke this by chapter, not by article per se. All right, continue, bro. On the other hand,
the circular of November 1, 1912, cannot apply to the Tangier territory, specifically refers to in the American memorandum, since Tangier and its purlieus do not come under the regulations decreed in the protectorate. As to the Habu, or governmental land, the Guiche lands, the circular of November 1912 merely repeated in their respect pre-existing principles that are enforced in every state. That is to say, the principles that some land is public domain and inalienable. And again, bringing forward that principle, the resident general merely availed himself of the power to issue regulations granted by the Franco-German Treaty. In answer to the fault found with servitude zones, we are justified in holding that all purchases of land are permitted by the Act of Algeciras, Article 60, subject to the obligation placed on the purchasers to conform to the laws and usages of the country.
so you see that Article 11 of the Treaty of Madrid, Article 60 of the Act of Algeciras keeps coming up and it keeps coming up. They need all European, not just the United States. They absolutely need those articles because it's allowing them the right to hold the property. And you see what the Habu is, by the way, is government land as well. So is the building and the land attached to it. So however many acres the capital of Georgia sits on, that's all that is the Habu property. So there's also the building, the big Moorish domes with the arches and all the beautiful architecture. Wasn't built by no white man. Wasn't built by no settler. Wasn't built by no pilgrim. It wasn't built by no Jew. It wasn't built by no European, pale European. It wasn't built by no redneck. It wasn't built by no KKK. It wasn't built by no liberal. It wasn't built by no conservative. It wasn't built by Democrat. It wasn't built by Republican. Who built these buildings?
Moroccans.
These all Moors that built these buildings, all of them.
Period. But
Yeah,
who's
who's
occupying them
occupying them
right now?
right now? White folks, colonists.
Mm-hmm.
Mm-hmm.
All right. All right, brother. Continue.
In answer to the fault found with servitude zones, we are justified in holding that all purchases of land are permitted by the Act of Algeciras, Article 60, subject to the obligation placed on the purchaser to conform to the laws and usages of the country.
Pause. Pause. In answer to the fault found with servitude zones, we are justified in holding that all purchases of land are permitted by the Act of Algeciras, Article 60, subject to what? Subject to the obligation placed on the purchaser to conform to the laws and usages of the country. What country?
Empire of Morocco.
Right.
What
What
also?
also?
What
What
is
is
one
one
of
of
the?
the United
What?
States of America?
What? United States of America? No,
No.
Just United
Empire of
States.
Morocco. Empire of Morocco. What's one of? What is the obligation? What is one
One
of
of
the
the
obligations
Yeah, I
placed
know.
upon the purchaser that
Pay
they must
taxes.
conform to?
Pay taxes.
Well, yeah, but that's not what I'm looking for. We'll run into it upon reading further. Um, but it's subject to the obligations placed on the purchaser, which is the foreigner, and they have to conform to the laws and usages of the country. They're buying it in Morocco. The country is Morocco, so they have to abide by and conform to our laws, Moroccan law.
Point of interest. And when I said the United States, I know this is the land of Empire of Morocco, but the United States is using it and using our laws to do everything.
Well, they're not really using our laws. They're using if everything is based on American law. What they're doing is they're just invoking the treaty power that we're supposed to be invoking. But it's not the
Correct.
United States of America. That this specifically for this part where it talks about the laws and usages of the country, not the United States. It's specifically Morocco, and everyone else is in Morocco. So that means that statement is binding upon all the foreigners, including France, who's talking all this jazz right now. It includes them. Okay, brother, continue.
Islam. Oh, Mr. Bassett Moore's letter
No,
further
no, no,
on.
no, no, no. Now the Sharifian decrees.
Now that's true.
You see it?
Oh, pardon me. Now the Sharifian decrees creating zones of military servitude are precisely to be numbered among local laws, as the aforesaid Act of Algeciras could not presume to prevent on every subject whatsoever. laws, and usages, or include in that phrase only those that existed in 1906. Mr. Bassett Moore's letter
Further on,
Mr. Bassett Moore's letter further on asserts that the records of land titles, which must furnish the Cadiz with the means of verifying the validity of the contemplated transactions, are very incomplete.
pause right there. What was the question that I just asked? The laws of the country, the laws in conformity with the obligations and the laws and usage of the country. Now remember that? It was just the last paragraph. And I was saying that we'll get to that answer in the read. There you go, right there. So remember, the Qadi has to uh, validate the deed. You understand, Morris? That's one of the where it says subject to the laws and usage of the country. That's the law. The Act of Algeciras specifically states that the Qadis must verify the validity of the deed in order for it to transfer hands. That's one of our law, Moroccan law, pertaining to the Europeans, foreigners purchasing land or property in Morocco. Additionally, they must also pay a 2% tax for every transaction that takes place in Morocco. 2%. Every time there's a real estate closing, the empire's treasury should be deposited that sum, 2% of whatever the total value of the purchases, or the total purchase price, I should say. So if you bought the building for $1 million, you owe the Moorish Empire 200 grand.
Point of
That's the
interest.
law.
Point of interest. So, what you're saying is our Cadiz is going to have a lot of work coming to them to actually verify those lands in order to get that 2%. Is that what you're saying?
Yeah, but it's not going to be one individual. A Qadi is like the tax assessor of each county.
Yeah, it's gonna be like say in California, it's gonna be like maybe a hundred of them or something like that. Are you?
No, in California, it's probably going to be thousands of them. I mean, there's a bunch of counties. Each county is broken down into counties. That's why the Constitution recognizes mayors, because the leadership of each county is the mayor. That's the local level. So each mayor, or should I say, each county will have a tax assessor, i.e., a Qadi, who will be the head in charge of the operation. But it's an office which also holds a bunch of other uh, uh, junior Qadis, if you will,
Right, correct. Here you go.
to cover each county. So the work is more the work that's most involved is is manning those seats. But um, we already got the blueprint because it's the United States already has the tax assessor set up. We just got to plug into their system and start using the same system to charge them taxes accordingly. So what they think they've done to us, they've done for us. So the system is already set up. We just got to plug in. See, this is what you're talking about, plugging into the matrix. We just got to plug into the matrix, uh, with the with with the status or the position of the sovereign.
That term, plug and play, right?
Yeah. But as the sovereign, rather than any type of subordinate position. All right, continue, brother. Number 5.
Islam. As regards Article 63 of the Act of Algeciras, the protectorate government never showed any intention to evade its operation, and still more unfounded is the assertion that the Sultan gave notice to the diplomatic corps of measures aimed at the recovery of property never aimed at the recovery of property of the class referred to in the aforesaid article. Such a notice never was served. The only measures taken had for their sole object the prevention for the future of the wrongs, the settlement of which for the past must be effected in accordance with the procedure directed by the Act of Algeciras. 6. As for the customs, grievances formulated by the American government, the protectorate government is quite ready to give them full consideration when they are specified. The only case presented in the memorandum of February 13th has been investigated at Casablanca by our consul there. He reports that the agent of the vacuum oil company at Casablanca told him he had not the slightest ground for complaint against the customs authorities. But the memorandum of the Charge d'Affaires of the United States at Tangier, hereinafter discussed, having explained that the difficulties under consideration had occurred at Safi and not at Casablanca. General Liudi referred the question to the office of the comptroller of the debt of Tangier, which will furnish all the data with which the settlement of this customs difficulty may be taken up at the earliest possible date. 7. As regards the American claims against the Moxon, the government of the United States may be assured that they will be examined in the same light as all the claims of persons under foreign jurisdiction. Those already passed upon by the Commission of 1910 will be paid in toto to the beneficiaries out of the funds of the loan that has just been voted. 8. As for the Benatil case, our agency at Tangier gives me the following information confirmed by Mr. Philip, our consul at Tangier. It agrees with the information supplied by the Washington government. Jacob Benatil, an American simsar, having obtained a judgment from the Shah about 8 years ago in a real estate suit against several foreigners, of whom Mr. Fries was French, did not choose to apply to our consular court for an executor of the Cadiz judgment. The legations of France and America tried but failed to bring about a friendly settlement of the Cadiz award by a payment by Mr. Fries, the loser, of an indemnity to be determined by umpires. But our fellow citizen, arguing that the judgment against him had been obtained by fraud, would not listen to any settlement. Inasmuch, however, as the land in dispute lies within the Tangier zone, the American government cannot condition the relinquishment of its extraterritorial rights upon a settlement of this case, which by reason of its situs does not lie under the jurisdiction of the protectorate authorities. In order to arrive at a more precise knowledge, if possible, of what is asked of us, our agency at Tangier has been instructed to apply to the Charge d'Affaires of the United States for such information as he possesses about the American claims the government of the United States wish to have settled before recognizing our courts in Morocco. Mr. Blake.
You see how they're calling for the recognition of the French courts in Morocco by the United States. See, everything is taking place in Morocco. This is the colonialism of Morocco. Morocco has been colonized. So you see that the transition that proves the colonialism is the replacement of the what? Moorish courts with the French courts. So in the same transition, when we decolonize, we have to replace the American courts with the what? Moorish consular courts or the Moorish courts, period. So it's a transition that's got to take place. And that's why they must assist in that transition. They don't have a choice. It's the obligations. This is the treaty. This is what the treaty said. The same way they're enforcing it and speaking on it in this correspondence, it's the same thing with us. We're going to be enforcing it and speaking about it. There's going to be another set of correspondences similar to this, except it's not going to be France and the United States. It's going to be Morocco and the United States all over again, reclaiming everything. We're back for everything you owe, no longer oppressed, because now we overthrow those that placed us in this rotten mess. Continue, brother.
Mr. Blake's memorandum under date of May 7th, sent in reply to our charge d'affaires, comprises 14 claims, but 7 of these may be even now stricken out. The first 5, including Benatil case, belong in Tangier, and the other 2 in El Zar and Larak. They, therefore, do not come by reason of their situs under the jurisdiction of the protectorate. It cannot be brought into a discussion of the relinquishing of extraterritorial rights in the French zone. As to the other 7 claims, they are all routine cases, and most of them of a judicial nature. They do not offer, either in their character or their importance, a class of litigation which may afford ground to the United States for further postponing the relinquishment of its extraterritorial jurisdiction and privileges. The Resident General is, at any rate, even now making it his duty to set on foot an examination of those cases and investigations by the protectorate local authorities respectively concerned therein. But these cases apparently are not such as to warrant opposition as a matter of principle to relinquishing the American extraterritorial rights, since the Resident General is even now ready to examine and settle those cases in the most conciliatory manner. I deemed it expedient to relate herein above the explanations furnished by the Commissioner of the Republic, which answer every point in Mr. Bassett Moore's memorandum. These explanations meet every claim and objection of the federal government, both in satisfying inquiries bearing on specific points and in carrying promises as to minor points that could not yet but will be settled. Finally, the report throws a full light, as may be desired, on some other topics that do not seem to have been correctly understood or interpreted. The willingness of the federal government to recognize the protector's regulation powers cannot be doubted by the embassy or by the French government. I am convinced that Your Excellency will find in the foregoing explanations all the palliations you may wish for, and I have no doubt that you will, as has already been done by most of the other powers, agree to forego the benefits of extraterritoriality in the French zone of the Sharifian Empire and accept to place persons subject to American jurisdiction under that of our courts. Aware of the friendly and reciprocal goodwill which always presides over the settlement of such questions between our two countries, I cannot but remind once more in conclusion, Your Excellency, as Mr. Jusserand did before this in his notes of April 22 and June 10 last, of the high value my government would attach to the federal government's early accession to our request laid before it on August 29, 1913.
Thank you for that, brother. So we're starting to see more and more of what the discord is, what's taking place, what's happening, Captain. Well, again, a transition. Everything is being transferred into the hands of the French government. Can someone assist the good brother? I know you've been reading. I want to give you a break so we can move on to the next correspondence, which is now the United States responding back to the French charge d'affaires. I guess someone has to assist the brother, or you want to continue reading. I don't know if you're tired.
No, sir, I'm not
Islam,
tired.
okay.
You got it. You got it, say around. Peace.
Islam. Okay. Uh, Secretary of State. The Secretary of State in the French charge d'affaires. November, no, 1358. Department of State, Washington, July 24th, 1914. Sir, I beg to acknowledge the receipt of your note of July 16 in reply to that of the department under date of February 13th, 1914, relative to the recognition by the government of the United States of the French protectorate in Morocco and the desire of this government for the settlement of certain questions affecting American citizens and American proteges and their rights in that country. The American government has assured the government of the French Republic of its favorable disposition towards the reform which the French protectorate proposes, and will give the remarks contained in your note referred to above careful consideration.
It's wrong.
For the
Okay,
Secretary. Mhm.
hold right there. So you see, first of all, look what they said: American citizen and American proteges. When have we ever even heard that kind of talk as black people? We've heard American citizens, we never heard American proteges. I beg to acknowledge the receipt of your note of July 16th in reply to that of the department on the date of February 13, 1914, relative to the recognition by the government of the United States of the French protectorate. They're conceding to the recognition of the French protectorate in Morocco and the desire of this government, the United States, for the settlement of certain questions affecting American citizens and American proteges and their rights in that country. What country?
Morocco.
Mm-hmm. Morocco is a country. This is where we get the language. That's how, I mean, it's an empire, but an empire is a country. They recognized it as the country, Moorish country. The American government has assured the government of the French Republic of its a favorable disposition towards the reform which the French protectorate proposes, and will give the remarks contained in your note referred to above careful consideration. So, how are we American? How can we be American? They are the American. See, this is not some book, some literature. They came before Columbus, whatever. No, this is political correspondence between two nations, two European nations, a charge d'affaires and a secretary of state. So specifically, two individuals, two white dudes talking to each other about you and I in our country that we knew nothing of because we thought we came from Africa. And in their correspondence, in their conversation, they're referring to each other as the French government and the American government. So then where does that leave you, black man? Where does that leave you, FBA, Foundational Black American? Where does that leave you, Black American Indian? I'll tell you where it leaves you. Keep Go back and read this document. They refer to you as the native Moors. So you're none of that. You're just simply a native Moor of Morocco. Those who traversed to American jurisdiction from where, Moors? It's a question for the floor. Those who traversed, journeyed to the American jurisdiction from where?
Morocco.
Yeah, but from I'm trying to get you to use the language from the Resolution 75. Those who journeyed here from where? The plains of Morocco. See, that's what they said. The plains of Morocco. So we're
Indeed.
Moroccan, not American, not FBA foundational black. We are foundational, but we're not black Americans. We're the proper term would be foundational Moroccans, if you want to say it. But just Moroccans is that would suffice. That is kryptonite enough for the colonists. They did not want us to know about this, so as to maintain the obsolete nature of the nationality and its lack of effect. Okay, Sarah, you can continue to the next to the French ambassador to the Secretary of State. So that last document was the Secretary of State to the French Chargé d'Affaires. Now it's the French ambassador to the Secretary of State, corresponding back. Go ahead.
The French ambassador to the Secretary of State, French Embassy, Washington, November 4th, 1914. Mr. Secretary of State, in continuation of previous occasions, the last being the letter of July 16th, last from the Charge d'Affaires of France, relative to the claims in Morocco, preferred relative to the claims in Morocco preferred by the federal government, which is thought had better be settled before extraterritorial rights were relinquished. I have the honor to inform your excellency that the result of the latest inquiries prescribed by my government concerning those claims has just been made known to me, and I deem it my duty to impart it to you as follows. First, in regard to the Worshipful case, it appears from the investigation that the claim formulated in this memorandum of May 7th last by the representative of the United States at Tangier, that it was settled as early as the following month of June. The deeds of sale were straightened out at the time. On the other hand, as to Mr. Worshipful's being given possession by his common law native vendor, the case is one that involves Mr. Worshipful and his vendor on one side and the German agent on the other. Until lately, it was for the native from whom Mr. Worshipful held his rights to sue for the execution of the judgment rendered against his opponent to the German agent before the council court of that nationality, as Casablanca and the protectorate authorities were quite ready to facilitate when the time came the formalities required to enable the vendor, provided, of course, that he had previously secured an exequator of the appellate judgment to give possession to Mr. Worshipful. The war declared by Germany on France have brought German proteges under the operation of the common law. The execution of the judgment is now a matter for the local authority alone, to which the party concerned need only apply for a prompt and final settlement of his case.
So you see they have German proteges. Y'all see that?
Mm-hmm.
German proteges, American proteges, British proteges, Russian proteges, Italian proteges, French proteges, Dutch proteges, Portuguese proteges, and subjects. Continue.
Second, in regard to the vacuum oil company's claim touching some land it purchased from one bin Sada, and which it is said the Moorish authorities will not allow to be sold because of the land being Habu property.
Who who
Islam.
will not allow the sale?
Moorish authorities.
Moorish authority. And why not? Because it's Habu property.
Habu property. Mm-hmm.
So the Moors said, no, I think not. So while this transition was taking place, whereas the French were taking control of the empire, you still had what? Moorish
First
authorities.
authorities
Part of the transition. It was getting phased out as
controlling
well.
Habu property.
But that was part of the transition. They were being phased out as well. Okay, continue.
Being Habu property, the legation of the United States declared in a memorandum on the case that it could not consider any settlement bearing on Habu property to be applicable to its citizens and proteges before the forms required by Article 63 of the Act of Algiers had been complied with.
The
But
legation of the United States. You see, they keep talking about these legations, but then they eventually they became discontinued, and you'll see it in these correspondences as well. Okay, continue.
but in the opinion of the government of the Republic, the treaties of 1880 and the 1906 could not bar the Sharifian government from amending or perfecting thereafter the laws and regulations existing at the time of the signature of those treaties. Article 63, cited by the legation of the United States, can hardly be invoked in this particular case, since it deals with the examination of titles to Habu property occupied under certain conditions by foreigners in 1906, and the present case is that of the land purchased in 1913 by the Vacuum Oil Company, upon which there seems to lie certain Habu rights. It can hardly be doubted under the circumstances that the case in dispute is that of land purchased in 1913 by the Vacuum Oil Company, upon which there seems
No,
to
no,
lie
no. You,
certain.
you jumped. You jumped the paragraph.
I did.
It can hardly be doubted. Start over again, and where it says it can hardly. Is that where you were? Yeah. It can hardly be.
I
You
understand.
jumped the paragraph or a
I
sentence.
did. I'm sorry. Excuse me. Islam. It can hardly be doubted under the circumstances that the case in dispute is that of a land transaction, which, if it does partially or wholly concern the Habu administration, must be settled with the proper regard to the existing regulations governing Habu cases. The protectorate government, the protectorate government has nevertheless asked the Habu Department to institute a thorough investigation of that case, and the legation of the United States has been so informed. As to the various other questions, most of them of very little account: loss of an ox in 1911, the Benetal, Benetal case, which can only be settled in accordance with the existing law, theft, existence of which is not admitted, supposed to have been committed to the detriment of an American citizen, a money changer by trade bearing the name of Mohammed bin Ali, bags of sugar, 10 in number, lost at Larache, that is to say in the Spanish zone, etc. That was a lot. Islam. The acting agent and consul general of France at Tangier has obligations with the representatives of the United States in that city with a view to reaching the earliest possible friendly settlement of these few questions.
So this guy is a money changer by trade. Who?
Mohammed bin Ali.
And that's a more, and you know that's a more.
Okay.
And he's a money changer by trade. Sound like some Harlem Renaissance stuff, doesn't it? Mm. I mean, we are the same people, and we do the same stuff. It's just um, different periods of time under different statuses, but the culture, the ways of our people is, they just remain the same. Whether you're called Black or Moroccan, you're still are who you are from a cultural perspective, even if you may not recognize that you're doing things uh, that you didn't know your ancestors has always done. What's interesting is like the the flat top fade hairstyle that we used to wear back in the days. What does that look like? What does
Fez,
that?
Fez,
Fez.
Yeah,
Fez,
just
Fez.
like the Fez, kidding, playing them, just like the Fez. So we basically cut our hair in the shape of a Fez. Could you imagine what these people were thinking when they saw that, knowing that we didn't know nothing about it? Ugh. Anyway, Muhammad bin Ali, the money changer, my man. He was a he was a hustler.
Islam was that remember the rat tail with the flat top? It might have been something with a fez with the tassel. Islam.
Yeah, the rat tail it represents the tassel exactly. It's interesting. It would have been even more correct if they would have had the rat tail coming off the side of their head, right? But they
Right,
had it
right.
that would have been pretty. That would have been pretty fly. All right,
I gotta
continue.
bring that back.
Right,
The
exactly. I
babies will
can't
handle
do it.
that.
I can't do it. I can't grow
Right?
hair no more.
The babies will handle that for us. Okay. All right. Let me continue.
Yes.
The government of the Republic would fain believe that on the strength of the foregoing statements, which added to those previously submitted, are sufficient proof of the sincere readiness of the French authorities to bring without delay all these cases to a legitimate termination. The government of the United States will kindly, as it has repeatedly and lastly on July 24th, last intimidated to the embassy, make a favorable answer to the requests I have had the honor to present as early as last year, and to the effect that the government of the United States agrees, as has already been done by several European governments, to the abrogation so far as it is concerned of the capitulations in Morocco, wherever the government of the Republic has organized French courts.
Mm-hmm.
Pleased.
Be pleased, etc. Yeah. So the capitulations. We're gonna look into what that means, right? It says, make favorable answer to the request I have had the honor to present as early as last year, and to the effect that the government of the United States agrees, as has already been done by several European governments. They all have agreed to the application so far as it is concerned of the capitulations in Morocco. What is capitulations in Morocco? Basically conquest. Okay. So now the American legation. George Blake to the Secretary of State. Continue.
Um, Charge A. Blake to the Secretary of State. American Legation, Tangier, December 20th, 1914. British Charge d'Affaires informs me that owing to Turkish intervention in European war, British government has proclaimed a protectorate over Egypt. A full agreement having been rapidly reached between France, Spain, and Great Britain concerning the international regime of Tangier, Great Britain consents to recognize the French protectorate in Morocco in exchange for recognition of British protectorate in Egypt. British legation here will be immediately suppressed, and the British charge will be appointed diplomatic agent and consul general.
Okay, pause right there. So you see how they're just going to and fro the empire, just claiming stuff. Okay, so well, I would recognize your French protectorate if you recognize my British protectorate over Great Britain, over Egypt. You see this? And what legation? British legation. What's the legation, Moors? I'm afraid to ask this question, but I'm going to ask. What's the legation? And where was it stationed?
Diplomatic body in Tangier.
Mm-hmm. And what's the legation? Diplomatic post
Post, yeah.
for each signatory power in Morocco. So every country had a legation at the diplomatic body in Tangier in Morocco. You got your British legation, German legation, American legation, Spanish legation, French legation, Italian legation, Portuguese legation, Russian legation, Dutch legation, so on and so forth. So in this case, we're talking about the British legation. But what are they saying? They say British charge d'affaires informs me that owing the Turkish intervention in European war, British government has proclaimed a protectorate over Egypt. See, Egypt is part of the empire. Not only does it appear in the chapter 47 of the Circle 7 Quran, but it also appears in the correspondence with the other Charge d'Affaires, Hoffman Phillip, in 1906. Where is it at? Right here. Residence in foreign parts does not affect the nationality of Moorish subjects, and the Moorish government has no means of protecting its subjects permanently residing in other countries, with the exception of a so-called Moorish consul at Gibraltar and a Moorish agent at Cairo, Egypt. So over here, with this correspondence, the British had a protectorate over Egypt. A full agreement having been rapidly reached between France, Spain, and Great Britain concerning the international regime of Tangier, Great Britain consents to recognize the French protectorate in Morocco in exchange for recognition of British protectorate in Egypt, in Morocco. British legation here will immediately suppress, will be immediately suppressed. I'm sorry, and the British charge, which by the way, it says this is charge. That's why you see that little um accent line above the E, will be appointed the diplomatic agent and consular general. So the French, the Spaniards, Spain, right? The Andalusians, the Castilians, to be more correct, the British, they all had different zones in Morocco that they had as protectorates. But the main protectorate, the most famous one, the one that established all the rest of the protectorates, is the French protectorate. Okay, so to continue with the question, suppression.
The question of the suppression of the capitulations in the two countries is reserved for ulterior discussion and forms no part of the present understanding. Italian, Spanish, and our own are the only legation remaining.
There you go. You see, so the Italian legation, the Spanish legation, and the and the American legation are the only legations remaining, which means everyone had um everyone else had discontinued their legation. So you see that there's a gradual fall taking place in the empire. The empire is now losing its legations. So the only ones left right now, according to this document, is Italian, Spanish, and American legation. Those are the only ones that are remaining. Continue, sister.
It is possible that the international statues of Tangier may shortly be presented for the consideration of the powers, but their application will likely be deferred until the ending of the war, as otherwise the international character of the community would entitle the expelled representatives of Germany and Austria-Hungary to recognize technicalities.
So those were the ones that were expelled. And we know about Germany and why. Not sure about Austria-Hungary. Okay, continue.
In exchange for compensations elsewhere, all the powers, with exception of the United States, have now recognized the French protectorate. I see no reason why we should depart from our position that recognition of the French protectorate and suppression of the American legation must be deferred until the settlement of our outstanding cases has been discussed. This point of view is well understood and seems to be admitted by the French local authorities as being both logical and reasonable. Blake.
And that's and that's the end of the read by Mr. Blake. So, as we see, we just played the role of a fly on the wall. Granted, we're quite late. It ain't never too late. But this is 1913, 1914. This is 2026, and we finally get to be a fly on the wall to hear what's really going on behind the scenes regarding the politics of the black man, who's actually the native Moor of Morocco, who then became a Moorish subject or protege as an American citizen based on naturalization. And we also see what is it that the United States will be seeking or asking of us. The adherence to these treaties, specifically Article 11 and Article 60. Article 11 of the Madrid Convention and Article 60 of the Algeciras Conference that allows them to hold property subject to the obligations and the laws set forth by the Act of Algeciras. And now the modern Constitution. Oh, don't forget about the modern Constitution. That's another set of Moroccan laws. It's irrelevant if it's modern. It exists now. And so therefore, their activities in Morocco has to be in alignment not only with the Act of Algeciras, but also the Constitution and any other legislative act that comes from the House, period. We govern them. But they're going to want to secure or make sure that there's certain rights secured based on the treaties. So this document gives us a look into what the attitude of the United States. Isn't that what this document is called, or how it's labeled? French protectorate in Morocco, relinquishment of extraterritorial jurisdiction by certain foreign powers. Attitude of the United States. So we just got a glimpse into the attitude of the United States regarding the transition of power. Right now, in today's political climate, they are feeling themselves. They weren't feeling themselves that much as now back then. Because for one, the empire was in existence. For two, the French had sway over it. And three, they were the youngest nation to come into the fold. The youngest. Everyone else had been here before the United States. They're the latest and youngest nation to come into the Moroccan fold as of 1836 or 1789? The first Treaty of Peace and Friendship. I suggest that the Moors go back and take a look at this document, examine it, read it, share it with others, right? Because it really gives you an insight as to what it is that we're to expect upon negotiating with the United States for the transfer of power that's pending. It's pending, and it will happen. All right, so now let's take a look at Oxford Public International Law, Capitulations by Christine Bell. Somebody read this for me, please.
Start with A, introduction
Yeah, start. You can start there. Start with subject.
of subjects. Military matters, armed forces, peacekeeping. Published under the auspices of the Max Planck Institute for Comparative Public Law and International Law under the direction of Professor Ann Peters, 2021, and Professor Rudiger Wolfram, 2004 to 2020. A. Introduction. The term capitulations in international law refers to the capitulations regime, that is, the system of treaties concluded by certain states which confer the privilege of extraterritorial jurisdiction within their boundaries on the subjects of another state. This system was largely dismantled in the period between World War I and II.
Keep in mind that during the correspondence with France that we were just going over, that was during World War II. So we see the term capitulations in international law refers to the capitulations regime, that is, the system of treaties concluded by certain states which confer the privilege of extraterritorial jurisdiction within their boundaries on the subjects of another state. Which treaty would that be in alignment with regarding the Moorish Empire? Think about it. That is the system of treaties concluded by certain states which confer the privilege of extraterritorial jurisdiction within their boundaries on the subjects or the citizens of another state. What treaty would that be that established the regimes of capitulation?
Hmm.
Which treaty gave the Europeans the right to protect the Moors? It's in the name of the treaties, Moor.
Treaty of Peace and Friendship.
It
It's the
protectorate rights
Algeciras.
in Morocco.
What was that?
Protectorate rights in Morocco.
No, that's not what it's called.
Um,
Good.
The affairs.
Nah, Algeciras.
oh,
I'm giving y'all the answer. Y'all still guessing. The brother had it, but he's just saying it wrong. The
Yeah,
right
you that is?
of the right of
Yeah.
brother. You gotta put yourself on mute, Chief Judge from Vita. The right of
Mm-mm.
protection in Morocco.
No, my little grandbaby, she'll be jumping
the
off
Treaty
that
of Madrid.
motherfucker. Shit.
Hey, Chief,
No,
Chief Judge
no,
of
she'll
Vita.
bust her there, man.
Hey, Chief
You
Judge
gonna
of
put
Vita,
that
you
over
over
in the
there wilding,
counter.
man. Oh,
Shit,
I
how
gotta
are they
be
gonna get
mindful
there?
of your.
She's just gonna have.
Uh,
You gonna have to watch it again.
y'all be killing it, man.
You're gonna have to mute them, so
Yeah, that's what I'm doing. I think I've already muted him. Yeah. Okay. Which treaty allows protections for the Moors? It's in the word, it's in the language, it's in the question. Protection. Right of protections in Morocco, in which you find Article 15. Treaty of Madrid. Treaty of Madrid is the right of protections in Morocco. Same treaty, 1880. But that's what gave the um capitulations regime. So it's a regime, right? The United States or any other foreign power. Capitulations is the surrender of the Moors, and it was accepted and confirmed by the Sultan because they became naturalized. So the naturalization part is the capitulation. So the naturalized Moors in America capitulated, those men and women capitulated to the American jurisdiction as Negroes, blacks, and coloreds. The American jurisdiction is what? The regime. the regime of capitulations or the capitulations regime. And so the treaty accepted it, but then also did what? What did the treaty do for the Moors? Who accepted the capitulations as American citizens, naturalized American citizens? What that treaty did for those Moors?
Give protections as proteges.
No, that's what I'm saying. I said, what else did it do for the Moors? What else did it do for the Moors? Yes, it did, gave them protections by the foreign powers. What else did it do for the Moors? Article 15.
Section 1, yeah.
Y'all killing me.
Give us the right to
It allowed us to
repatriate,
return back to the empire.
repatriate back to the empire, Islam.
All right. So it allowed us to repatriate back to the empire. Okay, brother, continue with part B.
Part B, the capitulations regime. 2, the origins of the concept of capitulations lie in the word capitulo. Capitulo or chapter, reflecting the fact that the provisions were set out in various chapters. Originally, the term did not have the connotation of surrender, as does the words contemporary ordinary mean.
You see?
3,
Surrender. You see? The connotation of the word is surrender. Capitulations. Who surrendered?
Moors.
Mm-hmm. To what? To what? To a regime. What regime? What regime did the Moors surrender to, Moors?
French,
United
then
States.
American.
Yeah.
What was that?
The French, then American.
Someone else?
Spanish for 800.
Who are
The
the signatory
Italian and
powers?
the Italian and the French, or the Italian. You just read it.
And the
Islam.
British.
Oh, British.
Islam.
We talking about Grenada?
No.
No, that was a long time ago, Mo. We talking about recently in the 1900s.
Talking
Oh,
about the
okay.
Treaty of Madrid, brother.
Oh. And
How
what
many
was the
signatory
question?
powers of the Treaty of Madrid? How many signatory powers of the Treaty of Madrid?
Was it 12?
Who are
It was
they?
supposed to be 13, but 12 and
European
Who are
powers.
they?
the European
European
power.
powers.
Who are they? Who are they?
The UN.
The colonial powers.
Oh man. Okay. Let's see.
Britain, Germany, Russia,
Thank you. Thank you.
France.
The
Thank you.
colonies.
Those are the regimes, plural. So the Moors surrendered to the European powers, who are the United States, Great Britain, Spain, France, Italy, Russia, Germany, the legations. Every legation, every foreign legation in the diplomatic body is a regime. And all the Moors, depending on which territory they were in, they capitulated, they surrendered to that regime. So
Divvied it up.
lock it in your minds, Moors. The Treaty of Madrid and the Act of Algeciras are composed of 13 signatory powers, Morocco being the 13th. So it's 12 other signatory European powers. Those European powers are the United States, Great Britain, France, Germany, etc. It's not just Italy or France and Great Britain. The same signatory powers of the Treaty of Madrid are the same signatory powers of the Act of Algeciras, with a few exceptions, because India is an unofficial signatory. So the Treaty of Madrid is about the right of protections in Morocco, okay? Which afforded you, which gave you the right to repatriate back to Morocco from being a black man. Now you can reclaim your nationality. You don't reclaim your nationality through a temple. You don't regain your nationality through a website. You don't reclaim your nationality by putting it in the paper. You don't reclaim your nationality by filling out a written affidavit and sending it to 7 whatever government bodies, U.S. government bodies. How do you reclaim your nationality, Moors?
On submitting repatriating back to the empire, entire submission back to the empire.
That's the Moorish way, according to Article 15. But anyone can repatriate. How does an Italian American repatriate back to Italy?
By renunciation and expatriation.
Mm-mm.
Submitting back to the laws of the
No, no, no,
Italy.
no, no, no. Hold up. Malinke. You're half right, half wrong. By renunciation, and then what?
Ex renunciation and repatriation. Thank you.
There you go. Not expatriation. You had already expatriated. So expatriation means you left your country to go be a part of another country. Repatriation means you're coming back to your country. You're renouncing and repatriating. So that's how an Italian would uh, go back to reclaim their nationality in Italy. The Moors is basically the same thing, but except we didn't have the empire to do that with. Now we do. So that's what Article 15 is all about. So Article 15 is about the protections of the Moors who became naturalized, which is now giving them also the leeway or the passage to come back to Morocco. Then what is the Treaty of Act of Algeciras about? What is that one about? Trying to give y'all the jewels so you can remember this stuff.
Yeah, taxation.
What was that?
Point of interest, Sultan.
Yep.
In the French Protectorate in Morocco treaty
No.
between
Hold up. You got to answer my question first. What does the Act of Algeciras do? And then we'll address your question.
Islam,
What does the Act of Algeciras do?
Taxation and regulation.
No, Moors. No.
it gives us our right to claim our nationality.
It gives back.
Oh, that was Article 15. Article 15 gives you your right to reclaim your nationality of the Treaty of Madrid, 1880. Then the Act of Algeciras
Speaking
is
about
what?
first.
What does the Act of Algeciras do?
It's an act to set up the Moorish government.
It gives it all back, Moors. It gives it all back. It gives it all back. It gives us back the sovereignty and independence, integrity of domains, economic liberty without any inequality. It gives us back the governance over the taxation. It gives us back control over the great enterprises. It gives us back control over the police. It gives us back control over the public services and public works. It gives us back the control over the Moorish ports. It gives it all back. So what does the Treaty of Madrid do?
It
Gives us our nationality right to return home.
Well, it's a two-part question, a two-part answer. What's the first thing it does? It gives you protections. The right of protection in Morocco. It's called the right of protection. The answer is in the name of the treaty. The right of protections in Morocco. It gives you protections. And then it also turns around and gives you the right to come back to Morocco. So it gives you the protections as a naturalized citizen in a foreign jurisdiction. But then it also gives you the opportunity to return back to the Moroccan jurisdiction. Ask the question again. What does the Treaty of Madrid do?
Yes.
The Treaty of Madrid gives us our protections and gives us the right to return home with our nationality.
Okay. And what does the Act of Algeciras do?
And the Act of Algeciras gives it all back.
Okay. Simple as that. Nothing, no need to overthink it. No need to mention taxation. It gives us back the right to tax. That's not the answer. It gives us back the right to do everything. Is the proper answer.
Islam.
It gives it all back. But in order for that to happen, we have to come from under the surrender, don't we?
yes,
We
Yes,
have to
indeed.
sir.
we have to stop
Indeed.
surrendering. We got to stop acquiescing. We got to stop accepting the conquest and do what?
Become
Rise up.
active. Active.
Get active and rise up in what? What's required for us to rise up and take back our sovereignty and independence?
Unity.
Okay.
Conformity.
Unity, loyalty, conformity, obedience.
Turn it
Yes,
up.
sir.
Continue, brother. The history of the capitulations regime.
Point of interest,
Yes, yes,
Sultan,
yes. Go ahead with your question.
before he goes any further. Yes, my question was about in the French protectorate in Morocco between the French embassy and the U.S. Secretary of State. Were they acknowledging that Egypt is in the territories of Morocco?
They didn't specifically say that, no. That wasn't specific. What they were saying is that Great Britain had a protectorate in Egypt, and in exchange for Great Britain recognizing the French protectorate, they wanted the French to recognize the British protectorate in Egypt.
Okay,
Now,
so
what I
my question,
showed, go ahead.
sorry. I was going to say my question to you is then, where is Egypt at this time?
What do you mean, where is Egypt at this time? What do you mean by that question?
As far as understanding of where Egypt truly is. I'm trying to understand if this is about where Egypt truly was in these territories of Morocco, or are they speaking of Egypt as in Africa?
Oh, yeah. Yeah. From the northeast all the way down to the southwest, all that is the Empire of Morocco. Now, can we legally uh stand on it and confirm it? No. Because in the treaties, there is no Egyptian signatory. That's why for now, the only ones that we can stand on officially by law is the 12 signatory powers. So those are the ones that are signed on to the treaties. We also know that by way of uh, colonization and the acceptance thereof, we know certain territories that are Moroccan territories. So, like Brazil, the reason why we know Brazil is a territory of the empire because who colonized Brazil? The question for the floor.
Spaniards.
Try again.
Portuguese.
Portugal is who colonized Brazil, and Portugal is one of the signatory powers. You see? And that's how we know that Brazil is one of the is part of the Empire of Morocco. All the Spanish-speaking countries, the Latin American countries, who colonized those countries?
Yeah.
Who colonized those countries?
The 12 signatory powers.
No,
Oh,
the Spanish-speaking countries.
yeah.
Who colonized those countries?
Spain.
Spain.
Thank you.
Spain. Yeah.
We have an answer and don't be saying
So
it.
Spain. So now that's how we know that Panama, Chile, Argentina. Brother, you got to mute yourself, Marvin.
Islam.
You got to mute yourself, or whoever's got that background noise. So this is how we're able to identify those that are those countries that may not be necessarily in the treaty, but at the very least are colonized by those who are in the treaty. Make sense? Hope I answered that question. But our decolonization efforts is strict in a strict sense dealing with the 12 signatory powers. And we'll build from there. Cross the bridge when we get there. We'll deal with the sovereignty of, all the other colonized territories when that time comes. In the meantime, we got to deal with the United States and other sort of signatory powers to get to that point. Slowly but surely, we'll continue to build. Okay, brother, you can continue to read.
Islam. 1. History of the capitulations regime. 4. The term capitulations came to be associated with the Ottoman Empire and has sometimes been understood as originating from the way in which Muslim states sought to accommodate non-Muslims by exempting them from the application of Muslim law. However, a better view is that the capitulations regime reflects a survival in our own times of legal conceptions of the latter Roman Empire. The Heir 207, quoting Sir Edwin Peers, and in particular its conception of sovereignty and jurisdiction as based on citizenship rather than territory. This historical view of capitulations illustrates how extraterritorial rights were granted fairly, routinely not only between Christian and Muslim, but between Christian and Christian, Christian and pagan, and Muslim and pagan. Heir 207, as much for economic reasons as for reasons of group accommodation. 5. The Byzantine emperors, for example, negotiated treaties in 907, 911, and 944. C.D.H. Kaiser, E.D. The Laws of Russia, 10th to 15th centuries, Volume 1, Schlack's Salt Lake City, 1922, 1 through 13. With the Varangians in Russia, which contained provisions on extraterritoriality. In 1093, Amalfi maintained a consular court at Naples in accordance with table or treaty provisions. In England and the Netherlands in the 15th century, Italian consuls had judicial functions indicating a jurisdictional role for Italian citizens. From 1082 AD onwards, Byzantium provided Venetian merchants with preferential treatment in trade, freeing them from local tariffs and allowing Venetians to maintain courts of their own Quran. Around the same time, French and Italian cities exempted each other's merchants from customary commercial tolls and to some degree allowed foreign merchants to organize their internal affairs according to their own laws. In the 14th century, in the Muslim states of North Africa and the Levant, Foreigners of each nation were often gathered in one large area with shop, chapel, and consular residence all located there. In the Greek Empire and Christian states in Syria, foreigners sometimes received whole streets or even a quarter of the city for their churches, residences, and other amenities, with all having the privilege of extraterritorial jurisdiction. Angel 254 through 250, through 55. In 1306, the kingdom of Cyprus exempted the Venetians from taxation and granted them the privilege of being judged by their own magistrates. These privileges were confirmed by succeeding kings, Susa 265. The Hanseatic League of the 14th through 17th centuries established an economic league of cities where economic benefits for foreigners came at the price of restrictions vis-a-vis local inhabitants in terms of where they could live. 6. Early capitulations, therefore, had an economic rationale designed to facilitate commercial relationships between cities or jurisdictions. However, in addition to giving foreign traders preferential economic treatment, capitulations gave them the right to maintain national independent jurisdiction in recognition of differences in laws, customs, and manners, and was often facilitated by their density in a particular geographic location. Susa 358. Although economic rights were conferred and jurisdiction given up by the grantor country, this was not viewed as having benefits which flowed in one direction only, as capitulations relieved the grantor of exercising jurisdiction over foreigners and facilitated their confinement to particular geographic areas within cities. 7. Over time, the capitulation regime was extended, in particular with respect to the Ottoman Empire. From the capture of Constantinople, it's Constantine, but how you say it at the end?
Constantinople.
Constantinople by the Turks, and thank you, Sultan. Constantinople by the Turks in 1453. Decrees of sultans granted extensive privileges and powers to European residents on their soil, originally as personal grants, valid only for the life of the grantor, the sultan. The actual term capitulation seemed to have first been used in the Treaty of 1535 between France and Turkey. G.E. Norodongian Recul de Actis International del Empire Ottoman, Volume 1, Libre.
You don't have to read that stuff in the parentheses and all the funny things. Just skip past it.
Islam between France and Turkey, which appears more specific and formal than any other decree. The Treaty of 1740 between France and Turkey confirmed this grant with 85 articles, which formed the model for subsequent treaties as other nations claimed the same favorable treatment. Thayer documents how by the mid-19th century, 13 Christian nations of Europe and 2 of the New World possessed extraterritorial privileges in Turkey. The predominance of these capitulations is often attributed to the Turkish desire not to enforce Muslim law upon the Christian resident alien. In the absence of us gentium, such as Roman law capable of being applied to strangers, the approach was to leave those strangers to apply their own law between themselves. However, capitulations retained their link to trade and were applied to commercial transactions by giving them preferential tariffs as trade incentives, and also by promoting harmonization of commercial law in the direction of European norms.
Preferential what? Tariffs? Say nothing new. This is Moorish stuff. I want you to read. I wanted to go further into another section real quick. I think it was here. And I believe is here. It's in when they get into right here, number 11. Read that.
Um, Elements of the capitulations regime, however, continue to have legal effects. In 1952, the International Court of Justice, ICJ, engaged with capitulations treaties in the case concerning rights of nationals of the United States of America in Morocco, France versus United States of America. France brought a case before the ICJ against the United States with respect to the legality of the decree of 30 December 1948 issued by the Resident General of France in Morocco, then a French protectorate. The decree provided that imports not requiring an allocation of foreign currency required licenses, except those from France. The case was the first in which the U.S. appeared before the ICJ in contentious proceedings as either plaintiff or defendant. The U.S. argued that the decree violated the rights of U.S. citizens under treaties providing for capitulations, namely the Convention for the Settlement of the Right of Protection in Morocco, signed 3 July 1880, entered into force 3 July 1880. The General Act of the International Conference of Algeciras relating to the affairs of Morocco, signed 7 April 1906, entered into force 31 December 1906, and the most favored nation clauses of its treaty with Morocco of 1836. The ICJ found that the decree was not compatible with the treaty rights of the U.S. It held that the U.S. was entitled to exercise consular jurisdiction in all disputes, civil or criminal, between citizens or protégés of the U.S., and that the decree therefore could not apply as between U.S. citizens. However, the ICJ rejected the U.S. argument that their prior treaty rights meant that they had to give prior express assent to all laws and regulations that purported to affect U.S. citizens, or that U.S. citizens were exempt from taxes.
Period. However, the ICJ rejected the U.S. argument that their prior treaty rights meant that they had to give prior express assent to all laws and regulations that purported to affect U.S. citizens. No, you don't. And they also were trying to say that they didn't have to pay taxes. Yes, you do. So the U.S. citizens are not exempt from taxes. So they have to pay taxes. In other words, that's what the ICJ concluded. I wanted you to skip over into this section because you see what it says here. The U.S. argued that the decree violated. They got some nerves. They'll be quick to invoke these treaties. Let's see how they respond when we invoke it on them, though. You see, because it is in like manner. Okay, so the decree, the U.S. Where was I? The case was the first in which. Let me see. Hold on. The decree provided that imports not. No. What was that part? The convention. What happened? Did I just lose my position here? But let's go back. France brought a case before the ICJ against the United States with respect to the legality of the decree of 30 December of 1948 issued by the Resident General of France in Morocco. Now, this is 1952. We were just reading that in 1913, 1914, weren't we? So this has been a thing. It became amplified in 1952, but it was already a situation since 1913, 1914. Then if Resident General of France and Morocco, then a French protectorate. The decree provided that imports not requiring an allocation of foreign currency required licenses, except those from France. The case was the first in which the U.S. appeared before the ICJ in contentious proceedings as either plaintiff or defendant. The U.S. argued that the decree violated the rights of U.S. citizens under treaties providing for capitulations. See, those treaties provided for the capitulation, right? Namely, the Convention of the Settlement of the Right of Protection in Morocco. See, that's the full name of that treaty. Is the Convention for the Settlement of the Right of Protections in Morocco. Short title, the Right of Protections in Morocco. Shorter title, the Treaty of Madrid, 1880. Signed July 3rd, 1880. Entered into full force July 3rd, 1880. So that's one treaty that gave them those rights. What other treaty? The General Act about International Conference of Algeciras relating to the affairs of Morocco. Signed 7 April 1906, entered into force 31 December 1906. Because remember, they had to go back and forth to figure out if the Sultan was going to sign. And the most favored nation clause of its treaty with Morocco of 1836, the Treaty of Peace and Friendship. The ICJ found that the decree was not compatible with the treaty rights of the U.S. It held that the U.S. was entitled to exercise consular jurisdiction in all disputes. But in the case, it said that they had limited jurisdiction, not full jurisdiction, in all disputes, civil or criminal, between citizens or proteges of the U.S. You see, so citizens or proteges, right? Who are the citizens? Officially, it was the U.S. citizens, the Americans. The proteges were the Moors, and that the decree therefore could not apply as between U.S. citizens. However, the ICJ rejected the U.S. argument that their prior treaty rights meant that they had to give prior express assent to all laws and regulations that purported to affect U.S. citizens, or that U.S. citizens were exempt from taxes. No and no. You're not exempt from taxes, and it doesn't require your prior assent, meaning prior permission. The laws apply to you regardless. Okay, so this is what the capitulations of regime basically means. Okay, then it also talks about the end of the capitulations. But now let's go into, real quick, same resource, Oxford Public International Law. This is the case of France versus United States. United States nationals in Morocco case. United States nationals in Morocco. The United States is in Morocco. Factual background. Go straight to the factual background.
Actual background. Two, after the end of World War II, American commercial interests in the French zone of Morocco increased rapidly, and huge amounts of goods were imported from the U.S. At the outbreak of World War II, a decree by the French resident general in Morocco subjected to imports, imports which did not require allocation of foreign currency, exempting, however, imports from France or from the other parts of the French Union. Based on U.S. protests brought after the war, the requirement of licenses was abolished by the Moroccan authorities in 1948. Upon intervention by the French government, the 1939 decree was replaced. In the same year, by the Arrêté Residentiel du Third, the 1948 decree, pardon me, once again subjecting imports not requiring official allocation of foreign currency to the regime of licenses. The effect of the 1948 decree was to restore the import regulations introduced in the earlier 1939 decree. Imports without official allocation of currency were again subjected to a system of licensing control. These import regulations, however, did not apply to France or other parts of the French Union. Such imports into the French zone of Morocco were free. 3. The U.S. government protested energetically and repeatedly. In October 1950, the U.S. ambassador in Paris informed the French government that the temporary assent given by the U.S. government to the application of the 1948 decree might have to be withdrawn for technical reasons in connection with the Hickenlooper Amendment to the Economic Cooperation and Administration Act. The Hickenlooper Amendment, see Economic Cooperation Act of 1948, Marshall Plan European Recovery Program, stipulated that credits were to be withheld from any country having dependent territories where, in the opinion of the U.S. president, the provisions of the Economic Cooperation Act of 1948 were being violated. Or in this regard, The French government presented to the ICJ the submission that the 1948 decree was in conformity with the economic system applicable to Morocco. According to the conventions which bound France and the U.S., furthermore, the French government presented to the ICJ submissions relating to the most favored nation treatment, the applicability of French laws and regulations to U.S. citizens in the French zone of Morocco without the prior consent of the U.S. government, the extent of consular jurisdiction of the U.S. within the French zone of Morocco, the extent of the tax exemption in the French zone of Morocco for U.S. nationals, and the interpretation of Moroccan import law. General Act of the International Conference of Algeciras relating to the affairs of Morocco. The Act of Algeciras, defining the value for customs purposes. The government of the U.S. requested, in particular, that the submissions and conclusions presented by the French government be rejected on the grounds that the French government had failed to satisfy the burden of proof and that the treaty rights of the U.S. and Morocco did not impose prohibitions on American imports, save those specified by the treaties, and those rights were still in full force and had full effect.
Yes, indeed. They said it again. U.S. and Morocco. All right, continue. The merits.
Regarding the 1948 decree, the ICJ ruled that Morocco retained its personality as a state in international law and that the rights of France and Morocco were defined by the Traité entre la France et le Maroc. So for the protected states. All right. Therefore, France was not accorded a privileged position in Morocco regarding economic matters, relying on various treaties between the U.S. and Morocco. The ICJ held that the 1948 decree led to a differential treatment, which was not compatible with the rights acquired by the U.S. Furthermore, by virtue of a most favored nation clause, the U.S. had the right to object to any discrimination in favor of France in the matter of imports into the French zone of Morocco. Accordingly, the ICJ unanimously held that the respective submissions by France had to be rejected. In relation to the French submission concerning the extent of U.S. consular jurisdiction in the French zone of Morocco, the ICJ unanimously found that the U.S. was entitled, on the basis of the 1836 Treaty of Peace with Morocco, to exercise consular jurisdiction in all disputes, civil or criminal, between citizens or protégés of the U.S. The ICJ also found by 10 votes to 1 that the U.S. was entitled, by virtue of the Act of Algeciras, to exercise consular jurisdiction in all cases, civil or criminal, brought against citizens or protégés of the U.S. to the extent required by the provisions of the Act relating to consular jurisdiction. Further rights of consular jurisdiction by the U.S. were, however, rejected by the ICJ with regard to the applicability of the laws and regulations to U.S. citizens in the French zone of Morocco, absent prior U.S. consent. The ICJ decided unanimously that the U.S. was not entitled to broadly subordinate the application of such laws and regulations to its nationals in the French zone of Morocco. To broadly subordinate application. The respective ICJ decision is subject to various qualifications by the ICJ. With respect to the tax exemption of U.S. nationals in the French zone of Morocco, the ICJ, by 6 votes to 5, rejected the U.S. contention that their nationals were exempt from taxation because the disputed taxation did not contravene any treaty rights of the U.S. Lastly, the ICJ ruled on the French submission and the respective U.S. counter submission relating to the interpretation of the Moroccan law on import and export duties, Act of Algeciras. In this regard, the U.S. maintained that the respective purchase value of the goods in the exporting country, plus expenses incidental to their transportation to the custom house in Morocco, were relevant, whilst France expressed the view that the words in the legislation meant the value of the goods in the local market, i.e. the Moroccan market. by 6 votes to 5, the ICJ decided that the value of the merchandise in the country of origin and its value in the local Moroccan market were both elements in the appraisal of its cash wholesale value delivered to the custom house. According to the ICJ, the power of making the valuation rested with the local customs authorities, but was a power with which must be exercised reasonably, in good faith, bona fide, and in light of the principle of economic equality, particularly without discrimination to all importations, regardless of the origin of the goods or the nationality of the importers.
You know how they brought up, how the ICJ brought up the principle of economic equality again? See, that comes up because of the fact that it's the equity that was brought back into the fold on behalf of all the Europeans to be on equal footing. Okay, continue your assessment.
8. The contemporary significance of the United States nationals in Morocco case arises mainly from its contributions to the development of international law concerning the areas of most favored nation clauses and consular jurisdiction. In addition, as the first contentious case in which the U.S. appeared before the ICJ, the historical importance of the decision also merits mention. In the end, however, perhaps the ICJ's primary achievement in the United States nationals in Morocco case was to help bring about the settlement of a long-standing dispute between France and the U.S.
Yep. So the France and the U.S. have a long-standing relationship and dispute because they've been a tug of war for the empire. That's the end of that read. For the empire and the protections of the nationals of the Moors, because having control of the Moors means that you have control of the empire and all the resources and the wealth that comes along with it. The currency is the energy of the people.
On the privilege.
Go ahead.
So this is the history. How I look at it, it's the history of them, like them battling for the booty and prize of the Empire of Morocco. Now,
Right.
by us learning this, we can figure out how to combat this and prevent this in the future based on this, based on these hidden documents and things.
That's what
And
we're going over.
yeah, and then that was just the perspective that came to me. I wanted to share it with you all. Islam.
But we're going over it so that we can see what really happened so as to not allow it to happen again. So that was the end of the read regarding the correspondences, the relinquishment of extraterritorial jurisdiction in Morocco, imposed by the French government after signing the Treaty of Fez and gaining authority over the empire as the colonial era of the empire. But the empire is still in the colonial era. It's still in a colonial status. Because the kingdom of Morocco has absolutely nothing to do with the Empire of Morocco. The so-called independence of the kingdom has absolutely nothing to do with the independence of the empire. It's a big difference. Two totally separate legal entities. One is the kingdom, one is the empire. The empire is still in the colonial, is still under colonialism. And the kingdom, well, that's a different story, which they're still under a level of colonialism, neo-colonialism of sorts, because France still has some sway over the kingdom.
They're a monarchy too.
And their monarchy, but when it comes on to the empire, it's in a shallow grave, which makes it even worse. It's in a shallow grave and is being colonized in such a status because it's in a shallow grave. But who's really in a shallow grave? Who is really in the shallow grave? Shallow grave.
The colonists,
No,
the Arabs,
the Moors. people.
Oh,
The black man,
yeah.
he's in a shallow grave.
The Moorish peoples.
Moorish peoples. Now, the empire has come out of the grave, but the people are still in the grave. You see,
Mhm.
it's only but a select small number of people who are working to bring the bring about the full force and effect of Moroccan law, while the rest of the population of the empire are still under the regime of capitulations, i.e., surrender, i.e., acquiescence.
Yeah, it's
And
gonna
those
be
who have the knowledge of self are doing what amongst themselves? Those who got the knowledge of self about the empire and the Moorish identity, what are they doing amongst themselves?
charging,
Yeah.
charging fees and setting up what is it? Setting up commerce. It's like the
Hmm.
Europeans just operating commerce. That's it. You know, they ain't worried
Arguing.
about colonization.
Well, it's levels to it, right? There's different levels to it because on the higher level, you got another group that are doing what?
Focusing on decolonization.
Well, there's another group that's that attempted what?
Coup d'etats,
Hmm.
failed coups.
So, so the Moors who are aware are infighting on different levels, from the lowest to the highest.
Right. That's crazy. When
Hmm.
you think about the history, it's like it's the same thing going on. And
It's the
then we
same
got it.
thing.
Yeah, and then we got it to where, the United Nations says we got a right to do this, the charter. But then the UN, the C-24, they try to make it to where the Kingdom of Morocco is the original and only Morocco, and they want to shut everybody else down. And it's interesting. It's gonna be interesting. But we stick with the laws and we enforce it. We enforce it on them, and it's gonna be
Hmm.
interesting.
The fight is on all different types. It's so many fronts. It's a whole lot of chessboards on the table.
Yeah. We invented that. What is it? That 3D chess? What is it?
Well, just chess. Period. We invented chess. Period.
I seen
whatever
something about
whatever version. There's all different types of versions, but chess is chess, right? So the
right.
Moors invented chess, and we go first. We're the white piece.
Islam.
So it's shameful. It's absolutely shameful that we're having to fight each other, right, before we could achieve sovereignty and independence. Well, it is what it is. Let's go. Let's do it. Let's
Mm-hmm.
do it. Fight whoever. Jermaine, Diaz, Spencer, whoever. Whoever. Let's
For real.
go. Let's get it done. Let's do it. Care nothing about no Negro with a fez who don't know nothing about black liberation. Nothing. Nothing. He's like Johnny come lately. He knows nothing about the black liberation. The man just learned about what an ankh means 7 years ago. Did you hear what I said? You just found out what an ankh is and you've been wearing it on your shoulders for 20 years?
Mm.
Yeah. Oh, my colleagues kept asking me about the ankh, and I didn't know what it was, so I had to look it up, and that's how I found out about Taj Tariq Bey. That's how he learned about Taj Tariq Bey. He had to go do some research on the daggone ankh. And you gonna sit there and tell me what? You've been on the white man's side all your life, sir. You've been a good old boy.
Shoe shining.
Been a good old boy your whole life.
Then
Mr.
come to the war.
Mr. Mergers and Acquisitions. Like he said, he was taught by the white sharks. Mr. Democrat, Obama lover. Then Malcolm X, Il Malik tell you in the Ballad of the Bullet that if you vote Democrat, you a chump and a traitor to your own. Well, he just proved it. Love him some Jasmine Crockett and all the Negro Democrats. I didn't grow up like that. I'm not a Democrat, I'm not a Republican. Neither party. Fist in the air, Black Panther Party. Vote for none of these folks. Not Trump, not nobody. Not Obama, not nobody. The argument was a revolution. The argument was liberation. The argument was to establish our own nation, not continue the participation of and the continuance of their nation. See, he has always been a protege. That's what he is. That's what he was. And that's what he still is. He's a protege. He's not a more for real, for real. He's more than likely a federal agent. More than likely.
Speak the truth.
More than likely. A federal agent that was under the tutelage of these people. He will tell you that. See, that's the forked tongue that people ain't listening.
He ain't hide the truth. He said it to release some of his karma.
That's what he did. Forked tongue. Forked tonguing his real status, his real position, who he really is. And that's a flawed individual who is still teaching classes as a chief judge.
I'm thankful I never got to meet him.
Still teaching classes, a political class as a chief judge because nobody else over there is capable. Did you hear what? Not even that fraudulent sultan. He can't read and he can't write and he can't talk. But he damn sure can sell you a whole lot of quaaludes. Right? Illegal substances. He's good at that. This is who Impact 2.0 is. You find out about people in hindsight. Jermaine Diaz Spencer is a demon. An absolute demon. And all the rest of his minions are too, because guess what? Birds of a feather
flock together.
Birds of a snake slither together. He's a snake, he's a serpent. And you see it in the AMPAC study sessions. Whatever happened to the AMPAC 2.0 banner? Oh, now we got the Empire of Morocco banner. What did we do? Trash the other AMPAC 2.0 banner? Because I kept calling it out? Because up until then, it was all good until I had something to say about it. Now we trash it and we put something else up there. Empire of Morocco, we're all together. No. It's the AMPAC 2.0 fools who are all together. The Empire of Morocco is about to get ready to complete the mission because the Europeans can't even trust to have no 2-decade career-long track record, rap sheet, drug dealing clown. That's no freaking sultan who knows nothing anyway. He knows nothing. He can't talk. This man literally told me that I'm not ready for primetime television to speak to CNN. That's why we cannot go down the political reforms of communicating with the media. because you, Sultan, you're not ready for prime time. Oh, so if I'm not ready for prime time, then good luck with the clown you have propped it up as some fake ass Sultan. Kendon. I like to see him on prime time. I like to see him on less than prime time. I like to see him on YouTube. If I'm not ready, then good luck with that clown over there. See, these things have to be expressed. These things have to be exposed. These things have to be discussed. Now, I don't typically go down the rabbit hole with them. I'll just mention a few things and I'll keep it moving. But right now, what we have uncovered is the proteges who have kept us from moving forward. Dayton we Moors, the gatekeeper boule factions, plural,
Come on.
of our nation. Gatekeepers. And it's varying stages of the gatekeeping. There's varying stages of the sellout by our own people. And the latest attempt is still fresh. The latest attempt comes from a disgraced and removed, dishonorable demonic person by the name of Jermaine D.S. Spencer, who is leading a foreign faction, foreign to the empire, that was attempting to usurp the sovereign authority of the empire and the Sultan, the office of the Sultan, and the will of the people. They are called AMPAC 2.0 and is being led by Jermaine D.S. Spencer, Monica Ortega, and some dude named Dre, along with somebody named Kendon Bay as a fraudulent fake Sultan and a fraudulent fake speaker named Makara L, and obviously a removed, disgraced, fraudulent chief judge by the name of Jermaine Diaz Spencer. I do not recognize his Moorish name. I don't recognize him as a Moor. Blackamoor, maybe. Negro, more like it. But not a Moor, because a Moor is a man of honor, nobility. You cannot wear that black fez with that type of character that will never be recognized by me or my office or the empire. He is better off as a low-down U.S. citizen along with his cartel family. Did you hear what I say? Along with his cartel family. Oh, it's a whole nother story that he didn't know I knew. The cartel will be coming to see you real soon, sir. Because your character brings about such contention that may not be good for you. And the empire ain't got nothing to do with that. It's between you and your personal relationships. See, God don't like ugly, and karma is a mother effer. Good, better, and different, because karma is good too. What you do, you reap what you sow. What you give is what you get back. So you give good, you get back good. You give bad, you get back bad. So considering this being the third coup d'etat attempt within the decolonization movement, we know what his near future is looking like. With that said, we're getting ready to close out. Any comments, questions, and concerns before we go?
Point of interest. I just want to ask you something. Could you email me a copy of this recording?
I certainly will, brother. Let's get the study in so that we can understand what the questions that are going to be asked by the foreign United States, what is their attitude regarding the transition of power. So we got an insight as to what their attitude was with the transition of power when France was transitioning the Moorish courts, consular courts, to the French courts. Now let's see. Now with that understanding, it gives us a certain perspective on how to approach the negotiations with the United States to ensure that which they want, they shall have according to the treaty. So whatever the treaty says is what you can have. Any other forms of negotiations, well, we'll cross that bridge when we get there, but just know it will never be a situation under which the empire will take lesser in any contract or be subordinate to any contract with the Europeans of any sort, whether it be the United States, Russia, I don't care who it is. We shall maintain our sovereignty and independence, the integrity of our domains, and the economic liberty without any inequality, so help me God. Islam, long live the empire and His Majesty the Sultan. Peace and love. Have a great evening. See you next week.
Long live his
Long
majesty.
live the Empire of Islam. Long live the Empire of Majesty the Sultan.
I love y'all.
Islam.
Islam.
Peace and love.
Peace.